defending himself. There can't be any debate that he was defending himself. At this point, it's law of the case, it's collateral estoppel, it's double jeopardy, whatever we may wish to call it. The jury has found that he was justified in shooting and even killing the assailant. The man apparently attacked him because he didn't like the way he was holding his dog. There was evidence suggesting that the man was under the influence, but in any event, the jury found that Mr. Drennon was justified in what he did. The state's position, in essence, boils down to this idea that felons have no right to self-defense. In this appeal, the question is, should the judge have instructed the jury on 1322, which provides that it is a defense to a felon in possession law and various other technical gun possession crimes if you are defending yourself. I contend that the judge here, aided by the negligence of two different defense counsel, committed plain error by not instructing the jury on this defense, and in fact by basically instructing the jury on the opposite. He said that they asked him, which crimes can self-defense apply to? He listed two crimes. He omitted this crime, which very clearly implies that self-defense cannot apply to it, and so he gave them the wrong instruction. He instructed them on the opposite of the law. Now, the state has basically... What
about the fact, wasn't there proof that the defendant possessed the weapon before his encounter and after the encounter? I mean, it's not like he possessed it in a vacuum and only had it when, and I'm not sure what all the facts specifically were about the man who was upset about the dog, how he came at him, whether that constitutes a crime in which the defendant was a victim. But how do you get around the fact that he possessed the weapon before and after that incident?
Yes, Your Honor, and that brings me to the heart of the dispute I was just about to cover. The state has basically disputed two or three elements of plain error. The first one is that they say there wasn't any clear law violated, and just simply put, I submit there was a clear law because the law is clear that a judge has to give a complete and accurate charge on the law.
Is there any, I got to tell you, I had been a judge a while before I was aware of this section in the code that provided a defense to that. But are there any cases or is there any law in Tennessee that requires a judge to instruct that, or that has found a judge erred by failing to instruct that particular section? There's
very few cases. I think I'm only aware of one case that has even addressed the statute at all. So in answer to the question of have there been other appellate cases that have specifically said a court should instruct on this statute, I think the answer is no. But I contend that a clear law was still violated because the law was clear from State versus Banks and I think numerous other cases that a court, whether it's in civil or a criminal case, especially in a criminal case, a judge has an obligation to give a complete and accurate charge. And so if he's given an inaccurate charge, then he's violated a clear law. And this statute, the state has basically asked Your Honor's question and said, can you point to another case specifically talking about the need to instruct on this particular doctrine? And I would say we don't really have to have an appellate case saying it because we have a statute saying it. And so if the judge is basically saying this statute doesn't exist, he's not he's not giving a complete and accurate jury charge.
It wasn't requested.
That's true, Your Honor, I agree. But the courts do hold that plain error can still apply even when counsel negligently fails to request a jury instruction. And
what about the fact that there was no objection when that issue came up with the jury and the trial court said that the self-defense was limited to counts 1 and 2?
Again, I would just submit that was negligence, and the fact that there was no objection might make a difference to this appeal if the state could point to something suggesting it was like a tactical, intentional waiver, but they can't, and I think that the record is just clear that the two lawyers messed up. Frankly, even if the first lawyer had waived it on purpose, I think the rules say that he still could have raised it in his motion for new trial. Basically, we wouldn't even have to be arguing plain error if the motion for new trial had at least been done right. And the second counsel here sort of touched on this issue in his motion for new trial, but he didn't argue it right. He argued it as insufficient evidence. He didn't ask for a new trial on this basis. And even if he had, he filed his motion for new trial a week or two late anyway. And so, in effect, there is no motion for new trial in this case. But so basically, our contention is that this issue was waived. It just was not waived tactically. And so plain error can apply. And getting, again, to the heart of Your Honor's question, the state is basically also disputing the two prejudice elements. And they're basically saying Mr. Drennon should have still lost even if the jury had been instructed on this.
Did you answer my question about how we deal with the possession before and after?
Well,
and I think we've kind of jumped into it. All of this is assuming that you think that there's the interest of justice we should waive the non-timely filing of the appeal, so we need to talk about that too. But
the state's argument here, like Your Honor's asking about, is that the self-defense couldn't apply because basically he already was wearing the weapon on his person before he got attacked. That's the heart of their argument. And to be clear, my answer to that...
And he took it with him when he left, and so
correct.
If they're assuming the elements of that statute had been met, or the defense would apply, he took the gun with him. The incident was over. He knew he was a convicted felon.
Right. And
he gave the gun back to someone else.
Right. I think that the evidence was that he gave it back to someone else not long after.
But he still possessed it.
It doesn't specify exactly how long after. But
don't you agree that was possession?
Yes, Your Honor.
When there was no crime occurring?
Yes, Your Honor. And to be clear, my answer to Your Honor's question is I contend that the statute creates a defense anytime you defend yourself with a handgun.
I'm not disputing that, but the way that statute's worded, it's a defense for possession during the crime, which, where you're a victim of a crime or you're defending someone else who's a victim of a crime, and that's an isolated incident.
Well, to be more broad, I contend that the statute creates a defense anytime you defend yourself, even if you were already guilty by illegally possessing a firearm prior to the attack on yourself.
I'm not sure I followed that. Try that again.
What I'm saying is the statute it doesn't say you're only innocent if you go obtain the weapon while you're in the process of being attacked. I'm saying that even if someone was previously guilty of the crime, if they get attacked and they have to defend themselves, I'm saying this statute creates an immunity for the prior possession that they would have been guilty of had they not gotten attacked.
I don't know how you can interpret this statute that way, because it uses the language during the commission of a crime, and the crime hadn't even started when he possessed it, and then the crime ended and he still possessed it.
Well,
I think you're asking us to read something into the plain language of the statute that's just not there.
what I'm asking Your Honors to do basically is to take the statute in the broad language that it does use, and not read into it an exception.
Well, I don't see it as broad language. I see it as very, very narrow language, which would make sense that it's, this very narrow exception to the crime of possessing a handgun after having been convicted of a felon.
Well, remember, this is not just about felons. This is about all types of illegal possession.
I understand, but I think that's the application in this case.
My conviction here is that that's not a reasonable way of attacking the statute, and it wouldn't make sense to interpret the statute that way, because if the statute were taken that way, the statute would have no practical effect, little or no practical effect. If I'm a felon and I get attacked by someone and have to defend myself, how would I ever invoke this statute if I didn't already have the gun on me?
But the reverse of that is also true. By your application of this statute, the way you want us to apply it, anyone who was otherwise prohibited from possessing a weapon could just use this and say, well, you know, I had this weapon for, you know, all this time after. I guess it would be hard to apply it before, but after the fact, I kept this weapon. And you're saying if someone had defended themselves and wanted to apply this defense, they could just keep this weapon forever because, you know, it might happen again.
Well,
And
it's not.
That's really about as broad as you're seeming to want us to apply it.
My contention here is that the purpose of this statute, the court previously addressed sort of the purpose in the case of State versus Tracy Clark. They said the statute implements a public policy of encouraging citizens to rescue a person reasonably believed to be in imminent danger of death or serious harm, and it protects the citizen who undertakes such heroic action from negative repercussions. And what I'm contending is that this is a negative repercussion that's been taken against Mr. Drennon after he had to defend himself. I contend that my view of the statute is supported by the doctrine of the rule of lenity, and that's basically that we're supposed to take the most favorable interpretation of a statute to this interpretation that's most favorable to the criminal defendant, provided that it's at least reasonable. I submit there's nothing unreasonable about my view here. Basically, I'm saying that if the charge results from an act of self-defense or defense of another, then the defendant's not even supposed to be charged. And I've also cited the drug overdose statute, which uses comparable language, which again says that no person is supposed to be charged, arrested, or prosecuted, even if that person is otherwise guilty. It creates an immunity, and the same thing should apply here. The statute we're talking about here says a person shall not be charged with or convicted of a violation of this part if the person possessed, displayed, or employed a handgun in justifiable self-defense. And so the result is a person shall not be charged. The condition is if the person possessed in self-defense. And so I submit the condition.
But you're leaving out the whole rest of that says in defense of another, in defense of that person or another during the commission of a crime in which that person or the other person defended was a victim.
Right. It's a true statement to say Mr. Drennon employed a handgun in justifiable self-defense during the commission of a crime in which he was a victim.
He may or may not have, but he had it before and after. And that's, I mean, we can just
Right.
agree to disagree
Well,
on your request for how you want us to interpret that and apply the statute.
And I guess we also have to take into account the fact that even if your honors might have doubts about my view, the question is ultimately, would a jury have found it persuasive, and is there a good chance that they, you know, that the interests of justice were prejudiced by not even letting them hear the defense.
So that gets back to this whole issue of the motion for new trial was late. Right, but this whole interest of justice business gets back to the issue that the motion for new trial was late.
Yes, Your Honor.
So if we're going to be looking this at all, it would be under the interest of justice view, correct?
Yes, Your Honor. And then
I do want to hear from you on that. I don't want your time to run out on what impact the late motion for new trial has on what we can do.
Well, my contention is that the law is, the Tennessee Supreme Court has specifically endorsed the tolling of the time to file an appeal during this same type of scenario before. And Mr. Drennon, he filed the notice of appeal on, I believe it was on the very same day that his motion for new trial was denied. It just turns out that the motion for new trial never should have been denied or ruled on. I guess the judge should have just said, you know, a year before that, you filed your motion for new trial late, I'm not even going to hear it. But that was overlooked by the judge, by the counsel, and by everyone else.
When you say the Supreme Court has said we should be told and heard, is that in this type of setting or a post-conviction setting?
I believe it. I didn't write down the case because I wasn't
Okay.
planning to focus on that issue in this argument, but I believe I did cite in my request to forgive the untimeliness a case that I think was from the Tennessee Supreme Court, where you had this same scenario where someone filed the appeal within 30 days of the motion for new trial being denied. But it turned out the motion for new trial was voided from the start. And so I just submit, there's no reason in the world why this court shouldn't be willing to hear the appeal. The state's been on notice for years that Mr. Drennon was trying to appeal and trying to ask for a new trial, and the fact that his lawyer, his appointed second lawyer, failed him shouldn't deny him the opportunity to appeal. Unless there are other questions, I'll come back for rebuttal.
Thank you, Mr. Justice. All right, General?
Good morning. May it please the court, counsel, my name is Will Lundy and I represent the state of Tennessee in this appeal. The state respectfully asks this court to dismiss this appeal because the defendant filed his notice of appeal almost 2 years after the time for filing had expired, and he offers no valid reason for this delay. And in the reply brief, the defendant attempts to justify this failure to file a timely notice of appeal by talking about how his trial attorney withdrew and then another attorney was appointed. I did check the record on that, and the defendant's convictions became final when the trial court, or 30 days after the trial court clerk entered the judgments. The trial court clerk entered the judgments September 22nd, 2022, and substitute counsel was appointed the same day. So there's really no excuse for why the motion for a new trial was late, and that was late to the tune of 57 days. We're talking about nearly 2 months.
Well,
Mr. Lundy-
unfortunately, go ahead, Judge Easter.
You sure? Okay. Practically speaking, let's assume we do dismiss this appeal because the
Yes, Your Honor.
motion for new, and then a post-conviction's filed.
Right.
You see where I'm going with this?
I do.
And then trial court grants a delayed appeal, and we're back here looking at this basically through the same microscope, basically the same microscope. Why not deal with it now under the theory of substantial justice?
The reason for that, Your Honor, is I think the time for filing a petition for post-conviction relief has also expired. I mean, so this appeal was filed almost 2 years late. We're talking about a year, 9 months, and 8 days. If my math is right, you can look in the record and see math isn't my strong suit. That's probably why I'm a lawyer. But in any event, the time for filing a petition for post-conviction relief expired long before the defendant filed his notice of appeal in this case. And so it's the state's position that the trial court wouldn't have jurisdiction to hear a petition for post-conviction relief in the first place.
Is that not a reason why, the interest of justice, we should allow the late filing, because otherwise this defendant's going to be precluded from recourse? And what prejudice is there to the state if we do make that finding and go ahead and hear it on these limited issues?
I mean, in the end, the issues that the defendant raises are, as the court I think has pointed out, are meritless here. But no, I think from a procedural perspective, I think there is an interesting question. You have, I mean, essentially what appears to be happening here is the defendant is attempting to sort of kind of backdoor a tolling issue into the post-conviction relief statute.
Unfortunately, this is not the first time we've seen this happen. After a trial's over, appointed counsel's ready to bail, and the trial court often appoints new counsel, and these things slip through the cracks. I mean, it's an unfortunate part of our process, but I think as trial judges, we've all seen that happen. And that's of no fault really to the defendant who had appointed counsel.
Well, I guess I don't know that that's necessarily true because I mean this court has has talked about how the defendant here hasn't asserted that circumstances beyond his control prevented timely filing for the motion for a new trial. We don't have any evidence in the record as to why this ended up being so late. We have nothing. I mean, the defendant clearly has said this happened. And absolutely, there's no question it happened this way. And defense substitute counsel didn't file the motion for a new trial on time. And then when he did, there was like a year delay or something like that before the motion for a new trial was actually heard. But we have no evidence in the record as to why that delay happened. And additionally, this court has held that where deferential standards of review apply to the issues in these kinds of cases, that also weighs against, the interest of justice requiring review. And so here we have one issue that's obviously conceded as plain error, and then we have a sufficiency of the evidence challenge, which is reviewed in the light most favorable to the state. And then we have the defendant's double jeopardy claim, which is meritless on its face. So there's really, I just don't see how the interests of justice merit review in this case.
What about what's meritless about his argument on self-defense?
On self-defense?
And the statute that he's arguing.
Sure. Numerous things. First of all, we're here on plain error. Everybody agrees on that. And so the defendant has a burden of establishing that an unequivocal rule of law was breached and that a substantial right was violated. Those are the two prongs I focused on in my brief. And as the court pointed out, the trial court did instruct the jury generally on the law of self-defense. And as far as I know, there's no case, either this court or the Supreme Court, saying that once that general instruction has been given, that this additional instruction from Section 3917 has to be given as well. And in the absence of such case law, that would make this an issue of first impression, which this court has said does not satisfy the clear and unequivocal rule of law test. And then secondly, as far as the court has pointed out, the statute here says that, it provides a defense to prosecution under Title 39, Chapter 17, Part 13, if the person possessed, displayed, or employed a handgun in justifiable self-defense, I believe, or defense of another, during the commission of a crime in which that person was a victim. And as, Your Honor, as you pointed out, the defendant admitted that he possessed this gun both before and after this offense, and the defendant's claim that this provides some sort of immunity to possession of a firearm for a convicted felon, first of all, it's not in the statutory language, and so he can't show that a substantial right was violated because he can't show that he wouldn't have been convicted anyway. And secondarily, insofar as the defendant is asking this court to interpret this statute to provide some sort of immunity for possession of a firearm both before and after the offense, there's no case law on this. And so because there's no case law, if we were here on plenary review, maybe we could take up that issue, but not on plain error. No clear and unequivocal rule of law was breached in this case. In fact, based on the evidence, I'm not convinced that this particular defense, because just as Your Honor pointed out, we have possession before and after the offense. I don't know that this was fairly raised by the evidence. And so I just don't see how the defendant can possibly prevail on plain error on his self-defense claim here. Moving on to the double jeopardy claim, I'm going to try and keep this simple. When a defendant obtains a new trial through a successful appeal on some basis other than sufficiency of the evidence, double jeopardy does not preclude retrial of the defendant. And here the defendant is asking for a new trial, essentially, on this jury instruction issue, or at least he's saying the trial court erred in not instructing the jury on this self-defense statute. But when we have a jury instruction error, the remedy is a new trial. It's not preclusive of other things. It's not, or it doesn't, double jeopardy simply doesn't preclude the new trial that the defendant would be entitled to if there was an error on a jury instruction issue, excuse me. Furthermore, the case Bravo-Fernandez that the defendant cites, in that case, what it says is that double jeopardy bars retrial when you have irreconcilable verdicts and you have acquittal on some charges and then the jury doesn't reach a verdict on these other charges. Those are the ones where double jeopardy would apply to bar retrial, not charges where a conviction has been had, a verdict has been reached. And so it really just doesn't apply. Even if this court were to conclude that the trial court erred when it failed to read the self-defense instruction, out of the firearms possession statute, the defendant would be entitled only to a new trial. Double jeopardy wouldn't bar that trial from happening. And finally, the evidence is sufficient to sustain the defendant's evidence tampering conviction. I know we haven't talked about that much. I'm just going to briefly go through it. The state was required to prove that the defendant knew that an investigation was pending or in progress. The defendant admitted that the police called him on the night of the offense. The state offered recordings of those conversations. There's no doubt that they happened. And the defendant didn't turn himself in for something like 3 days. I don't remember exactly. It could have been more or less, but it was about that. So he knew an investigation was ongoing, pending and in progress. There's no doubt that the defendant concealed the gun. I mean, he admitted that he knew the gun was a piece of evidence. He admitted that he got rid of it rather than turning it over to police. And he claimed that he returned it to its original owner shortly before he turned himself in. So there's obviously an intent there to keep the police from having that gun, which is the fourth thing that the state needs to prove, is that he intended to impair the availability of the gun as evidence in the investigation. And again, based on his actions, a jury could rightly infer that he intended to impair the availability of the gun. I see I have a significant amount of time left. That being said, the state's position is that this court should dismiss this appeal because it's untimely in the interest of justice, do not require this court's review. And secondarily, alternatively, if the court chooses not to dismiss the case, the state would ask this court to affirm. And with that, I'm prepared to cede the remainder of my time unless the court has further questions for me.
Right. Thank you, General.
Thank you, Your Honors.
On the timeliness of the appeal, the case I was talking about before is State versus Martin, Tennessee Supreme Court, 1997. And they said the failure to file a motion for new trial within the required 30 days not only results in the appellant losing the right to have a hearing on the motion, but it also deprives the appellant of the opportunity to argue on appeal any issues that were or should have been presented in the motion for new trial. And so after declining, they then mention the possibility of plain error. They don't find any plain error, but then they do move into the defendant's last issue, which was not something that was appropriate for motion for new trial, and then they do rule on that under plenary review.
Well, what in this record shows us that, it's in the end, other than, just the facts of we know and everybody agrees that prior counsel failed to file the motion, what in this record shows us that it is in the interest of justice to waive the timely filing?
The arguments are the jury very clearly should have been instructed on this rule of law. His first lawyer
So nothing in the record showing why it wasn't, nobody found it, and why it wasn't filed sooner, and nobody discovered the issue. I'm not talking, I understand your argument about the merits of, what needs to be addressed on this statute, but just anything in the record about why, is there an affidavit from prior counsel about, why he or she failed to file and why the second counsel failed to file and that type of information?
I don't think so, Your Honor, but the question is not whether they failed. The question is, what is the excuse for filing the appeal so late?
I understand.
So if we waited 31 days to file the motion for new trial, we should have gone ahead and moved to appeal
But
and asked
the appeal was late filed because the motion for new trial was late filed and wasn't heard for a long time, as you said. And so, yes, I realize the issue we're looking at is the appeal, but all of that relates back to the motion for new trial. And, if I knew of a good reason why all of that happened, I might feel like I had more information to say, oh yeah, I can see how that happened or that shouldn't have happened. We need to waive in the interest of justice.
I don't really know. I believe I heard something about a delay in transcripts being written up at some point. That's part of
But you don't know if that's in the record.
I'm not sure if it is.
Okay.
with regard, jumping back to the merits of this 1322 thing, I submit that my position not only is reasonable, but that a jury very easily could have found it reasonable. You know, I seem to recall that in the most recent Star Wars movie, there was a scene where one party teleports a lightsaber to another party in the middle of a battle. And under the state's view of this statute, that is the only scenario where Mr.
Well, that's not true. You could be at a bar fight and somebody could hand someone a gun, or they could grab one off of, or they could get a knife off the table. I mean, that's not, that's certainly hyperbole. There are, to me, specific examples of how that could happen and be justifiable under the statute, short of someone teleporting an instrument in.
I guess it is theoretically possible, yes, Your Honor, but I just submit that the state's view artificially limits what the intent of this statute, and again, that a jury could have found it.
Well, let me ask you that. The intent of this statute, now, again, when I read your brief, it sort of said maybe I misunderstood this statute from the beginning. I thought this statute was designed to say that if you illegally possess a weapon, that does not keep you from claiming self-defense against the act that you're defending against, not the possession of the weapon. And I understand, I've read the statute and it's very confusing. But if it is confusing, is there an unequivocal rule of law that was violated under the plain error standard by the trial court?
Our position is that the unequivocal rule of law is that the jury should have been instructed on a statute that undeniably applies, and the jury should have then gotten to interpret it the way they saw fit, as the final triers of fact and law, as the Constitution says. And I had meant to talk about the tampering statute conviction too, but I don't have time for that, so I'll have to rely on my brief. I just do want to be clear, I ask that the possession be reversed and the indictment dismissed and or a new trial, and that the tampering be reversed and dismissed. And if we only win on one of those, I do also ask for a remand for resentencing, if that happens.
All right.
Thank you.
Thank you, Mr. Justice. Interesting arguments, good briefs. Thank you. We'll take this under advisement. We're going to take a short recess.